please.
Thank you, Your Honor. Thank you, ladies and gentlemen of the panel. I appreciate your time. I appreciate you all being here. I think we have today here a serious issue, an issue that has very real and very immediate consequences for district attorneys and assistant district attorneys all across this state. We believe that in this case, the charges against Mr. Schultz arise from a misreading of two different provisions of the Rules of Professional Conduct. 3.09D generally governs the conduct of a prosecutor specifically with respect to disclosing exculpatory information. 3.04A applies beyond the prosecutor scenario to all attorneys practicing law and governs the prevention of another party from receiving evidence. And here today, what we believe is that the State Bar has overread those rules, created strict liability, frankly, as far as it applies to attorneys in this state, and ultimately created a situation where district attorneys are going to find it impossible to do their jobs, and frankly, where all litigators, regardless of stripe, have likely violated the rule with respect to 3.04A as far as they have interpreted it. And I'll unpack that a little bit more for the court here. But before I get into the specific rules, I don't want to rehash the facts of the case. That's in the briefing, and this is not a place to rehash the facts. But I think that when the panel considers how these rules are applied, which I think is necessary for determining how the rules are interpreted, it's important to understand the facts of this specific case, because I think the facts here are very important.
Well, let me interrupt you there. I think we all understand the facts of the case, and the question that I had to begin with, I'd rather you address is, it appeared to me from what Mr. Schultz said eventually is that he was aware of the issue relating to the identification of her assailant, but made the decision, right or wrong, not to disclose that. Is that a fair summary?
I disagree with that, Your Honor.
Okay, tell me where I'm wrong.
And here's why I disagree with that. What Mr. Schultz specifically testified to is that in a meeting leading up to the trial, he asked Ms. Uriostegui, who attacked you? She said it was her husband. He said, how do you know it was your husband? And she listed 4 factors. And this is exactly the point that I was about to drive at here, Your Honor. The fact of the matter is she listed 4 factors that are inculpatory. I knew him by the way he smelled, I knew him by his silhouette, I knew him by the knife he stabbed me with that he carried every day, and the boots that he made me clean every day. But here's where I think we're all missing the forest for the trees. The fact of the matter is that's not how Ms. Uriostegui knew that it was her husband. The fact of the matter is she'd been married to the man and lived with the man for 20 years. And so the reality is there were probably 1,000, literally, factors that she used to identify him. And the fact that she merely vocalized those 4, we know from the balance of the evidence that that's not even true. We know if we look at the police reports, which were submitted into evidence, that they actually yelled at each other. When he broke in and was attacking the other gentleman who was in the apartments, she starts yelling at him to leave the other guy alone, and he starts yelling at her.
Well, I don't want to, because I want you to use your time as effectively as possible. But again, the question that I have, and I'm not a criminal lawyer, I do civil trial work, but the question I have is, it appeared to me, first of all, that the defendant was never advised that she was not able to eyewitness identify him, but there were these other factors that, in her mind, led her to believe. Is that correct? She didn't say, I saw him, it was him. She was going off of other things that I'm sure can be identification as well.
I think that's a little bit incorrect. I think as you look at the balance of what happened in the case, she consistently said, it's him. And in criminal law, that would be sufficient evidence. It's him. And no one ever questioned that, including the defendant. As far as could she see his face, the defense actually had that evidence already. There was an interview done at the hospital right after her attack. And she informed the police officer taking her interview. The police officer said, can you describe his hair? And she said, no, it was dark. I couldn't see his head. So had the defense attorneys read that testimony, they would have already known independently that it was impossible for the witness to see her attacker's head. They would have also known from having looked at the police report that it was a dark apartment. The only light on was a television. If they had truly thought that they could make some hay out of her not seeing the defendant clearly, that was amply available to them. That was amply available to them. And as far as the specific testimony, did she tell Mr. Schultz that she did not see his face? We dispute that as well. What the testimony shows is that there were Ms. Uriostegui, who speaks only Spanish, her interpreter, and then there were 5 English speakers in the room. Now, the only 2 people, according to the testimony before this court, that heard her say, "I didn't see his face," are Ms. Uriostegui and the Spanish-speaking interpreter. The 5 English speakers in the room, all of them, said that they didn't hear that statement.
You've said you don't want to rehash these facts, but that's all we've been hearing. This is an evidentiary panel has already heard these facts, and now it's time to argue the law.
I appreciate that, Your Honor. It was just my endeavor to try to answer the panel's questions, so I'll move on. As we look at the law, we believe that 3.09D should be interpreted to be a codification of the Brady standard, and there are several reasons for that. One, I'll point out that the state's own expert, Judge Crusoe, who they offered, he actually testified that it was his belief that it was a codification of Brady. And I actually have a citation for that, if I can find it for Your Honors. Yes, that's on page 251, lines 20 through 23. The question, in your opinion, is 3.09D equivalent to what we refer to as Brady? The answer, I'll have to say yes, for a certain portion of it. So that portion, their own expert says it is Brady. Now, why do we think it needs to be Brady? Well, so far as we can find, every state Supreme Court who has taken up this question, there's 3 of them that we cite in the brief, have said yes. On the other side of that, they cite, Your Honors, to some law review articles, some lower court cases, which largely, as I can tell, are dicta, where they say, well, there's probably a difference here between Brady and this standard. But as far as courts that have taken on this question square on and said, our rule in our state, is it Brady? They've said yes. There's 3 of them. Now, why did they say that? Well, there are several good reasons. So one that you see in the cases is the risk of inconsistent standards.
So I have a question as to the inconsistent standard. So is it your position there's a separate set of standards for those that are innocent versus those that are guilty?
Not at all.
So anybody that's guilty should still have the same rights of exculpatory information and impeachment information?
Absolutely.
Even if they plead guilty?
Well, the courts have said that there's a difference there.
But no, I want to know your position. So is your position that once you admit your guilt, so for example, if I confess a week after the scene and there's all these statements which might indicate that she couldn't see him, does that then mean the prosecutor doesn't have to disclose that information because the person has confessed?
If you've merely confessed, then no. If you have pled guilty before a court of law and accepted the judgment of the court, yes. And there's a number of good reasons for this. You see this from the Supreme Court case in Ruiz. What the Supreme Court case there says is, very often prosecutors have an ongoing investigation. And they come after, let's say, a large criminal conspiracy.
But Ruiz is a drug case. There's drugs in the trunk, right?
Well,
so at that point, there wasn't a lot of Brady information in Ruiz because they knew at that point that she was the person that had the drugs. That was an impeachment case.
Well, but the reasoning stays the same. If you have a large criminal conspiracy, it's very common to go to one member of the conspiracy, get them to flip, turn state's evidence, they plead guilty, and then you can start getting information out of them. Now, under the state bar's ruling, that you have to tell them literally everything about your case before they plead guilty. Under the state's bar, that's what the state bar is saying, that the commission is saying. You have to tell them everything, every witness, every hole in your case, every confidential informant, every shred of evidence, every undercover police officer, everything before they plead guilty. And if you haven't done that as a prosecutor, your license is on the line. That's what this position says. And that's frankly an impossibility. If they haven't pled guilty, they could say, thanks for the info, and then go back and tell the rest of the criminal conspiracy. I'm not inventing that. That's literally what the Supreme Court says in that case, why it has to be that if they plead guilty, you don't have to lay out every single thing for them.
So at that point, if the detective or maybe the prosecutor concludes they are guilty early on in the case, should that make a difference in terms of what is disclosed to the defense?
Not at all.
Why not?
Because they haven't pled guilty. This is not a question of what the prosecutor consciously or unconsciously believes. This is a question of what they have walked before a court of law and said.
So was there a difference in time between when I know your argument is that Mr. Schultz didn't know, but if he had known, if the evidence suggests that he had known in those meetings, and that was before the time that the defendant had pled guilty, then he would have had to disclose that?
Well, under Brady, we have other arguments that it's not material. It was already known to them. But Your Honor, with respect, according to the Fifth Circuit, according to the Supreme Court, according to all the circuits we know of that have taken this up, the answer is no. Those courts have said as soon as you plead guilty, it's done.
I know, but if he hadn't pled guilty yet, so the prosecutor learns this in a meeting in August, and he doesn't plead till December.
There's a lot of hypotheticals here. If in fact it was said, if in fact it was material, if in fact it was unique, and if in fact Mr. Uriostegui had not pled guilty, if all of those things happened, then perhaps there would be a violation going into trial. Does that answer Your Honor's question?
It does.
And I think this leads into some of the other facts here. Some of the other factors on why Brady needs to be the standard is because it can reduce the chance for gamesmanship. And I think this is exactly a case of gamesmanship. If there is, under the Commission's interpretation, where regardless of materiality, regardless of whether it's already known, essentially if there's anything that a defense attorney could find out a prosecutor didn't disclose, doesn't matter if the defense attorney already knows it. Let's say that the defense attorney and the prosecutor are sitting in the same room, and they hear the same person say the same thing, and that's material evidence. But the prosecutor doesn't lean over and say, hey, I just heard what they said, and I need to tell you that. Then technically, under the state's bar reading, the prosecutor hasn't disclosed that information to the defense attorney, and the prosecutor has now violated the statute, has now violated the rule, the procedural rule. That's a ridiculous result. It's a ridiculous example. It's a ridiculous result, but it's the logical conclusion of the way that they interpret this rule.
Under Brady, is there can there be a Brady violation even if the prosecutor is not aware of the evidence? In other words, is there a knowing component under Brady, or can you violate it even if you're not personally aware of it?
Somebody has to be aware of it.
Okay.
Somebody with the state has to be aware of it. Now, that doesn't necessarily have to be the prosecutor, but somebody does.
Well, under 309D, does it not say known to the prosecutor? Isn't that the standard, known to the prosecutor?
It does say known to the prosecutor.
And isn't that different than the Brady standard?
Well, I believe it's a more narrow focus than the Brady standard, and in that respect it has to be, because the rules of the professional conduct don't govern police officers. So Brady expands a little bit to cover other parts of the criminal justice system, whereas the rules of professional conduct only bind attorneys. So it has to be that.
So in that sense, would you agree with me that 309D is less expansive than Brady? It's more restrictive.
I would say it's the same standard, but because it's a rule of professional conduct, it applies only to lawyers and none others. And that's what that language is designed
But under
to.
Brady, you can be charged with knowledge of someone else in your office, for example, could you not?
The state as a whole would be, but Brady doesn't charge a lawyer. Brady doesn't charge an individual.
Okay, now let me ask you, is materiality a requirement under Brady?
Yes, it is, Your Honor.
And under 309D, the language that I'm looking at is, quote, tends to negate, and goes on to talk about. Would you agree that that's somewhat similar language?
Well,
and if so, is it more expansive or less expansive than Brady?
So I agree that there should be a materiality component read into 3.09D, and I would agree that language gets there, and I would agree that language brings in the Brady materiality standard. The reason that's a dispute is because the Commission disagrees. In fact, they sort of have two arguments that they've conflated at the lower court, but they literally say, in their statement of the case and in their argument, and they made this argument at the lower court, that the four factors that inculpated Mr. Uriostegui, the four factors that supported the witness's identity of him, are exculpatory. And why are they exculpatory, according to the Commission? Well, because a defense attorney may have heard them and may have created a negative inference out of them, that is, because of these four things, no other things, which in and of itself is a logical fallacy. But a defense attorney might have had those inculpatory things and figured out a way that he wanted to attack something based on those inculpatory things, and so therefore they're exculpatory. That's literally their argument. And so I can't think of a less material piece of evidence than that. It's inculpatory. It can't be less material than that because it's inculpatory. And then even if you look at the second component that they combine in with the first, I didn't see his face. Well, this is where I was driving at earlier. Well, a woman of 20 years marriage, is it really material that she didn't see his face when they were yelling at each other, they were wrestling physically, she saw all these other things about her? As an analogy, I'll tell your honors, I have 3 small children, 8, 6, and 4. And from time to time, they come down to our room at night. They get out of the bed, they come down, pitch dark. I can wake up from a dead sleep and know exactly which one of my kids it is. I don't have to see their face. They don't even have to say a word. I know by the sound they make when they walk in the room. I know by just their presence. And we don't need expert testimony to prove that. Everybody here knows. Every juror would know. Every layperson would know. That's how human beings are. So I would suggest, Your Honor, that this is immaterial.
But he didn't ask her that. He didn't ask. You've been married 20 years and you knew that was Silvana. Didn't ask her that.
He didn't ask her when, Your Honor. Do you mean at the hearing itself? And that's a real problem because he didn't have the opportunity. In fact, one of the reasons that we're here is because Judge Burgess cut off his ability to rehabilitate his witness. Anyone who's done trial practice knows sometimes a witness gets shaky, sometimes you have to rehabilitate them, and Mr. Schultz just flat didn't have that opportunity. Had Judge Burgess allowed the hearing to go on, had Judge Burgess allowed Mr. Schultz to question the witness, to really dig into this, I think we very likely would have found that there was no question. She's a family violence victim and she got shaky on the stand. That's what happens here.
You don't think he could do that in a bill afterwards?
He was not given the opportunity. He wasn't given the opportunity.
You don't have to have a judge present to do a bill.
At that point, he received instructions that this is going a little bit beyond the evidence that we provided in the evidentiary hearing. And if Your Honors want evidence of this, we're happy to go back down and present it. But essentially, the district attorney's office said this is the way it's going to go, and that's the way it went. Mr. Schultz, it has to be remembered, isn't running the show with respect to this litigation. The district attorney himself is the one who's running the show with this investigation. For example, Judge Burgess found a Brady violation. Mr. Schultz, could he have had the power, should have appealed that, because it's clearly wrong. Judge Burgess's decision there is clearly wrong. Judge Burgess made a number of mistakes. In fact, declaring mistrial is a mistake. What he should have done was allowed Mr. Uriostegui to withdraw his plea and set the case for trial. I think very likely what we would have seen had that happen is Mr. Uriostegui pleading. Because there's really no question.
What do you, in just in connection with that, and then I think we'll give you a rebuttal time. What about the state admitting at the hearing that the evidence should have been turned over? And I thought Mr. Schultz, in effect, agreed with that. How does that impact our ability under the evidentiary standard to rule in his favor?
Mr. Schultz's admission was that he wished the whole thing hadn't happened.
I'm sorry?
He wished the whole thing hadn't happened. He wasn't admitting liability. His regret was that what really is a non-issue and should have been a non-issue turned into the tail that wagged the dog. That's really what his admission was. And again, there wasn't evidence of this at the trial because it's a little far afield, but my understanding, if we were to go down and present evidence on this, is that there was a understanding between the defense attorney, the district attorney, and the judge that they were going to go in, take their licks, the judge was going to give them some CLE, and then everybody was going to be done. The defense attorney, my understanding, didn't necessarily honor his agreement in that front and ran and filed a grievance, which was then later used as a political tool against the sitting district attorney in a very hotly contested election.
What about the state's admission that it should have been turned over? Is that in any way binding on Mr. Schultz?
I don't see any res judicata or collateral estoppel. Mr. Schultz was not a party. He didn't have the opportunity to appeal. He didn't have the opportunity to challenge. He had no authority to do that. So there should be no collateral estoppel or issue preclusion on that.
Okay. Any other questions? Anybody? All right. Thank you very much.
Thank you, Your Honor.
May it please the board. Good afternoon. The board should affirm the judgment of fully probated suspension for the simple reason that substantial evidence supports the findings of misconduct. And in the final analysis, this case really is that simple. Now, of course, to get to the final analysis, there are some other considerations that come into play that are important for the board. One is that Rule 3.09D does not codify the Brady Doctrine, and the other is that both of the rules at issue here should be construed according to their plain language. I want to talk about those issues, but first, I want to put this case in the proper context by focusing on the facts that matter to the analysis. And these facts are largely undisputed. What's not in dispute is that the victim, Maria, identified the defendant as her attacker based on 3 factors: his smell, the bottom of his boot, and his stature. So, in other words, this identification was based on unusual factors. I think there's no doubt about that. What is disputed, at least in the briefing, is whether the victim said to Mr. Schultz that she did not see the defendant's face, that she did not see her attacker's face. That's the question. Did she say this to Mr. Schultz? And he has devoted a large portion of his briefing to that question. However, that really is a distinction without a difference. The fact that the victim did not see her attacker's face is implicit in the method by which she identified him. Once she said to the prosecution, "This is the way I identified my attacker, according to these 3 factors," it was crystal clear that she did not see his face. So I think at best, any representation that Mr. Schultz wasn't aware that the victim did not see her attacker's face, that just comes across as disingenuous. And if there really is any question, there's an important exchange that the commission highlighted in its brief, and that I want to bring up here because it is so important. It's an exchange between the defense attorney and Mr. Schultz at the writ hearing. And Mr. Amador, the defense attorney, questioned Mr. Schultz. He said, and I'm quoting, "Outside from other indicators, my question to you is, you knew before February 13th, 2012, that Maria had not seen the face of the assailant on the evening of May 7th, 2012, correct?" And Mr. Schultz answered, "That's a fair statement by the way she identified her attacker, sure." So again, we're talking about a distinction without a difference here. Mr. Schultz knew, based on what he has admitted, that the victim did not see her attacker's face, and that's undeniable in this case.
Ms. Hamilton, I heard you say, and I believe your brief says that 309D does not codify Brady. Is that your position?
That is correct.
Do you believe 309D is broader than Brady?
I thought that was an interesting question that you asked, Mr. Kittner. I think it depends on the way you look at it. Yes, our position is that in general, in most cases, 3.09D is going to be broader than Brady. And that's because Brady really has 2 key issues that matter to a Brady analysis. One is whether the information at issue is exculpatory, and the other is whether it's material. And Brady and its progeny defined materiality. I shouldn't even say Brady, but the cases that came after Brady and fleshed out what is now the Brady Doctrine defined materiality very specifically. And if you compare that to the language of 3.09D, it's very clear that 3.09D really just deals with that first issue, which is whether the information is exculpatory in nature, whether it tends to negate the guilt of the accused. So the 2 are very different, and because you only have to cross one threshold in order to come under the purview of 3.09D, it's generally going to apply to a broader subset of information. It's going to apply to things that aren't necessarily material to a conviction.
Okay, well, let me stop you there. I hear the appellant saying all sorts of horrible things are going to happen if we have 2 standards. What is your response to that?
I think there's a very easy answer to that question, because because we're looking forward. If we look at what's going to happen in the future, which is what the appellant is urging you to do, we have a new standard in Texas. We have a very broad discovery standard now that tells prosecutors, basically, you've got to turn over information that is material. Because of that, really, that argument is a non-issue anymore. Perhaps before January 1st of 2014, it would have been an interesting discussion, but now it's just not.
So your position would be prosecutors should just forget about Brady and apply 309D? And they'd be safe in that sense?
Yes, absolutely. They have an ethical obligation to do that. And really, the best way to do that would be for a prosecutor to simply have a true open file policy. And that's what the new provisions in the Code of Criminal Procedure, that's really what they're aimed at. That's what the Michael Morton Act was designed to accomplish, was that there would be much more free sharing of information from the prosecution. So a prosecutor can make it easy on himself. He can have a true open file policy. If he doesn't want to do that, then it could be tougher, because the prosecutor is going to have to look at evidence and look at the information that is in his possession and determine, does this evidence tend to negate guilt? And thus, do I have an obligation under 3.09D to turn it over to the defense? So it's the prosecutor's choice. He can handle it the way he thinks is appropriate.
So then you don't believe that the outcome of this case would, in essence, create a strict liability for a prosecutor?
Absolutely not, no. If you look at 3.09D, it just so clearly dictates the result of this case and the judgment that was entered by the evidentiary panel, and in no way did the panel impose strict liability on Mr. Schultz. Really, as I pointed out, the information that mattered here, which was the method of the identification, was admittedly in Mr. Schultz's possession. He admittedly knew about it. That's the very information that we're talking about here. So he made a choice not to turn over that information. So, we're really far from a strict liability standard here.
What about a situation where a crime lab, like we know has happened in Texas, has somebody in a crime lab that's dry labbing or committing widespread fraud? Does the prosecutor then have an obligation to go through every single case that involves that testing through the crime lab and make a disclosure to the defense, or to be subject to discipline?
The commission's position is yes. The prosecution would have an obligation under 3.09D at that point to notify defense counsel of that information and to do that promptly.
What about a police officer that was disciplined for lying on a police report? Do they then have to retroactively go to every single case that police officer had handled in the past 5 or 10 years and notify defense counsel in all those cases?
Well, I think it would depend on probably the circumstances of the lie on the police report, but I think we are getting further away from a clear obligation to turn over information to the defense. I think it would probably just depend. The situation where we know about a crime lab employee, for example, that falsifies evidence is just such it takes that person's conduct into a realm of willingness to cross a line that makes that calls into question all the other work that person has done. I mean, if that crime lab employee is willing to take that step in one case, the defense should have an opportunity clearly to then examine what happened with that information in mind, to examine what happened in defense's particular case. Some important things to keep in mind here. Again, as I mentioned, both of the rules at issue here, 3.09D and 3.04A, must be construed according to their plain language. Now, if we look at 3.09D, the language is simple, it's straightforward. There's a small part of the language that actually applies here. And what that language says is, the prosecutor in a criminal case shall make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused. There is no mention of Brady. There is no mention of that very important aspect of the Brady Doctrine as it's applied now, and that is materiality. What we're talking about is a broad set of information that tends to negate the guilt of the accused.
But what if it didn't tend to negate? What if there were so many other external factors indicating that he did it, that it did not tend to negate, that the overwhelming weight of the evidence was that the person's guilty?
Well, I think that hits on the difference between Rule 3.09D and what it's designed to accomplish and the Brady Doctrine. In Rule 3.09D, the prosecutor really shouldn't be weighing this evidence and trying to predict what all the other evidence in the case is going to be and how this is all going to look in the end and decide whether this evidence is important. Really, if the prosecutor doesn't want to have a true open file policy, the prosecutor needs to try to look at this evidence without too much of a bias about guilt and determine whether it is of some value to the defense as the defense builds its case. That's what the prosecutor has to try to do. Trying to see the future, determine what's going to happen in a trial, that is so far beyond most people's capability that it's inevitably going to result in mistakes. And that's what 3.09D needs to stay away from. Your interpretation of the rule should focus on the individual evidence and its significance to the defense. That's the focus of the language of the rule. In this case, we have very strong evidence supporting the idea that the notion that the rule was violated. As I pointed out, Mr. Schultz admitted that he knew the method of the identification. That's the evidence at issue. It was not turned over. This question about did he hear Maria say that she didn't see her attacker's face really is irrelevant, although there is testimony in the record to support a conclusion that Mr. Schultz was provided with that information. He was told that she said she did not see her attacker's face. But that can be disregarded and we're still okay here.
Let me interrupt you a second, I'm sorry, but is it your suggestion that there's some bright line where a prosecutor will know, based on what evidence that he has, that he's got the duty then to disclose, as to not be in violation of 309D?
Not always. Not always. It can be difficult sometimes, and again, that's why a prudent prosecutor might consider adopting a true open file policy so as to not run afoul of this issue. It could be possible that information looks one way today, but another way 6 months from now, when other information comes to light, perhaps the particular defense that the defendant puts on. So there is a risk there. To try to understand a piece of evidence completely can sometimes be difficult, but if the prosecutor incorrectly, if he misjudges the nature of evidence, and that evidence is something that tends to negate the guilt of the accused, and he fails to turn that over, there is a violation of Rule 3.09D. Now, the exact circumstances could mitigate the offense, could aggravate the offense. It just depends, and that would have to be determined on a case-by-case basis. In this case, we don't have that situation. We have a situation where, based on the factors that Mr. Schultz emphasizes, for example, that supposedly Maria never wavered in her identification of her husband as the attacker. Multiple police reports supported that she didn't waver in this identification. The fact that discovery was openly turned over to the defense. All of these things made it more important that the prosecutor recognize the significance of the evidence here. It's really undeniable that this evidence, although perhaps it can be viewed as inculpatory from one perspective, it was also exculpatory. It went to a key element of the state's case. It went to the testimony that had to be provided by the state's star witness in order for them to establish that element, and that's the identity of the defendant. So the significance of this information really is undeniable. And again, Mr. Schultz himself admitted as much. Now, if we look at the other rule that's in question here, Rule 3.04a, like 3.09d, that rule is straightforward. The language is simple, it's plain, it's easy to construe. It says, a lawyer shall not unlawfully obstruct another party's access to evidence. The plain meaning of the words used in that rule are that it prohibited the conduct at issue. Mr. Schultz, whether intentionally or unintentionally, he misled the defense by responding to discovery as if he was providing all exculpatory information. By ostensibly providing that full discovery, he perpetuated the defense's mistaken belief that all exculpatory information had turned over, that the identification was unassailable. They acted on that belief. It's very clear from the transcript that defense counsel advised his client to plead guilty because he believed that the identification was unassailable. There's no doubt about that.
Hamilton, just so we get the State Bar, I'd like to understand the State Bar's position. You told me that you believe 309D is broader than Brady, correct?
Correct.
Do you believe 304 is broader than 309?
Is 304 broader than? Yes, potentially.
I know 304 doesn't just apply to prosecutors, but again, I just want your position. So to be completely safe, if your rules or interpretation are followed, the prosecutors should start looking at 304 and forget the other two to be safe. He didn't want to get somebody filing a grievance against him. Is that fair to say?
In some ways, yes. Now, we do have 3.04a does utilize some language that seems to make the reach of the rule somewhat narrower, and in that it does talk about unlawful obstruction of access to evidence. So there's got to be some other law somewhere that would say the other party should have access to this evidence that the prosecutor or the lawyer in general is hindering access to.
Well, I guess my point, and I hear this, I think, from the appellant is you've got Brady, you've got 309, you've got 304. What are we to do? And if you're turning around and talking to Mr. Schultz, what would you tell him?
Well,
What would you
I
tell him to
feel like
do?
I'm beating a dead horse, but I really think the answer is a true open file policy. That is not mandated by the rule, but that's the easy way to ensure that you're not tripped up by the rule, that you don't make an error in judgment and end up being tripped up by the rule.
So you tell Mr. Schultz, forget about the rules. Your best bet to be safe is just have an open file policy and turn it all over.
That's correct. And if that doesn't happen, then you better be on your toes. You better know what's in all that information. You better look at it carefully and consider it carefully. Know what's in your file and be able to identify what is required to be turned over, which sometimes will not include everything in the file, but you take that approach at your peril if you're a prosecutor.
So the rules then will dictate to an elected district attorney how he should run his office, lest
Well,
they
sure.
perhaps run afoul of the way the rules are being interpreted.
Sure, yes. I mean, I think the rules should dictate really to any attorney how the attorney should run his office, regardless of whether the attorney is a district attorney or not. And I think it's important to remember really what the prosecutor's function is supposed to be, and that is to reach the truth. That this case, that justice is served, and that in this particular prosecution, we reach the truth and we reach the correct result. Now, if that really is the goal, and prosecutors really are devoted to that goal, an open file policy is the only thing that makes sense. Keeping that in mind, there is no other answer to that question but yes. I mean, 3.09D should dictate what happens in a prosecutor's office at all times. It's a critical rule, and we've seen in recent years the severe consequences in cases where the outcome is different from this one, where it looks like we probably have a defendant who was almost certainly guilty and he didn't have to pay for what he did. He was walking the streets as a result of what happened here. That's not what we usually see in these cases. What we usually see in these cases are what we saw with Michael Morton. We see innocent people whose lives are destroyed and they spend a lot of time in jail because information that clearly should have been turned over to them was not. So the consequences of not following this rule can be so egregious and so harmful to both individual people and to society that prosecutors just cannot take shortcuts in deciding how they're going to implement these rules. We can't say the Brady Doctrine and all its gazillions of cases and the evolution that it has gone through since it was first adopted. Now, Brady versus Maryland, if you look at it, it's much more, it originally was, its effect was much more like Rule 3.09D, but it has been transformed dramatically since that time and essentially limited. Now, if a prosecutor's duty, his ethical duty under the rules really evolved with Brady, figuring out what that responsibility is at any given time would be extremely difficult and not consistent with the plain language of the rules. So in conclusion, what we have here is a prosecutor who lost sight of his responsibilities under Rule 3.09D. The undisputed information in his possession called into question a key element of the state's case. That information should have been turned over to the defense because it did tend to negate the guilt of the accused. It's just implausible to argue that that information was not exculpatory, and the panel reached the right decision here, and the commission urges the board to affirm the judgment.
Thank you.
Thank you.
Questions for Ms. Hamilton? Any further questions? Thank you very much.
Thank you.
Mr. Smith?
Thank you, Your
My
Honor.
first question, and then I hopefully won't ask you that one, but I probably will. What do you respond? Because I understand the concern you have, because it does seem to me there are several standards out there that are potentially applicable. But as Ms. Hamilton says, if you just follow 309D, you'll be fine. What's wrong with that?
It begs the question. The question is, what does 309D mean? She stands up here and she says, well, if they just had an open file policy, everything would be copacetic. Well, they did have an open file policy. They opened their file to literally everything that was there except for work product. What we're talking about, let's be clear, what we're talking about is one statement made at one interview, offhand. Now, they try to transform this into a case of Mr. Schultz intentionally withholding information. This is where the strict liability comes in. There is no evidence whatsoever, not a shred of evidence whatsoever, that Mr. Schultz intentionally withheld anything. At best, he was negligent. So the question is, why not just follow 3.09D? Well, what does that mean? That's exactly what we're talking about here. You know, one of the other reasons, I didn't get a chance to get to this earlier, but one of the reasons that Brady, we believe, should be the standard is because Brady is extraordinarily well developed. The commission takes the position that 3.09D, it's clear on its face, so it's easy to follow. Well, that's just not true. That's not how statutes work. We constantly go to court. We constantly get rulings on statutes. We constantly get interpretations, and that's how we as lawyers know what to do. Now, the fact of the matter is 3.09D has almost no case law supporting it, and that's an effect of the way that our ethics process works. Brady has a tremendous amount of case law interpreting it. If you want an answer to how something should be interpreted, you can go find it in Brady. If you want an answer to how 3.09D should be interpreted, good luck. I mean, we looked, and there's virtually nothing out there. So if you want to give prosecutors certainty on what they should and should not do, give them a standard where courts and litigants are constantly battering up against it, where our adversarial system actually comes to fruition and comes up with these, helpful standards, helpful cases, helpful fact patterns that just completely don't exist here. May
I interrupt you a second?
Please do.
Whether it was an offhand comment or not, if Mr. Schultz heard her say that I never saw his face, did that kick in a duty under 309D for him to disclose that to the defense?
Well, I believe no, because one, I don't think he heard it, but let's assume that he did. That information was already known to the defense. It was not really material to any of the issues in the case. They say that it is, but the fact of the matter is identity was never in question. Ms. Uriostegui had already testified in open court on the stand that Silvana was her attacker. There was procedurally, there was a protective order hearing early in the case. Mr. Uriosteguy's attorney was there, had the opportunity to question her. She was asked who her attacker was. She clearly and unequivocally identified Silvano. So Mr. Uriosteguy's attorney didn't question that. He didn't say boo. He could have asked her any and every question. He could have asked her how she identified him. He could have asked her if it was dark. He could have said, you said that you couldn't see his head. He could have done all of those things.
And I understand that. I guess my fundamental question still is whether or not the defense knew, if he heard that statement, did he as a prosecutor have a duty under 309D to disclose that to the defense?
This exact statement in this exact circumstance, I don't believe was, if he did in fact hear it, I don't believe the failure to say that to the defense was a violation of the standard. And frankly, the way that this was argued at the lower court, at the evidentiary panel, if this panel determines that that is the question, we need to go back and have a trial on that question, because that's not the question that was presented to the panel. The question that was presented to the panel was, are all of these things that support her identification, are those exculpatory evidence as well? They should have separated the two questions so that we had clear answers on those, and they refused to do so. We advocated for that at the lower court, and they refused to do so. So we don't have a clear answer as to why the lower evidentiary panel ruled in the way that they did. So if it's this panel's judgment that the real question here is, did she see his face? Let's leave aside the things that support her that are inculpatory, but the question resolves on, did she see his face? Then we need to have a new trial.
Well, that's one panel's member's question to you, because I want your opinion on that, whether or not that kicks in a duty under 309D to disclose to the defense.
Yes, Your Honor. I think have I answered your question?
I'm not really sure.
I think under this particular set of facts, no. For the reasons that we've discussed, that it's immaterial. All the Brady, I don't want to rehash all the Brady things.
No, I appreciate your answer. Thank you.
If I may, I know I'm over time here, but if I may just address the other, the 3.04A. Again, this goes back to what we were saying, what I was saying earlier with respect to the strict liability issue. The commission's argument is Mr. Schultz intentionally withheld this evidence. Well, there's not a shred of that. At most, he was negligent, according to the evidence that we have in front of us, in not disclosing it. Further, if you look at the comments to the rule and the way the rule reads, it requires some sort of overt action. It talks about obstructing, it talks about unlawfully. The question is, what is lawful? The comment 3 specifically, cites solely to criminal provisions. And really what 3.04A is designed to do is prevent somebody who actively goes out and destroys evidence in a certain way. The fact of the matter is that Mr. Uriostegui had unfettered access to ask Maria Uriostegui whatever he wanted. He had unfettered access at that protective order hearing to ask her all of these questions. So it would have been literally impossible for Mr. Schultz to have obstructed that access because he already had it. For those reasons, Your Honor, if there are further questions, I'm more than happy to answer them, but I am over time and I want to be conscious of that.
Let me just ask you, because again, it does seem to me in some senses there are different standards floating around here, but why wouldn't it just be, as Ms. Hamilton says, just follow 309D and you'll be okay?
Because
I guess that's what I'm searching for here, because again, it does seem difficult if you're the prosecutor. I've never been one, but to make that decision, and if it's a wrong decision, all sorts of bad things can happen, not only to the public because you have somebody loose who shouldn't be, but also to yourself, as you point out. You could lose your license.
We keep talking about this word decision as though there was a point in time when the prosecutor sat down and said, do I disclose this? Do I not disclose this? Do I disclose this? Do I not disclose this? And that's just not the reality of how a prosecutor, that's not how it worked in this case, and that's not the reality of how a prosecutor works. They're overworked, they have huge caseloads, they have people constantly coming in and out. In fact, on this case alone, there was a shuffling of prosecutors one after another as people are reassigned. And that's a common thing. So the question of well, why not, let's just tell them everything. It would be impossible for a prosecutor to literally tell a defense lawyer everything unless the prosecutor had the defense lawyer with them whenever they did anything. Anytime a human being takes an information and then sends it back out, something is lost. You know, everybody knows the telephone game where people repeat a thing around a circle. Well, the message is always lost, and the reason for that is that we are imperfect at repeating information. Unless we literally record it or literally have the defense attorney there, that's an impossible standard. It's impossible to say, just tell the defense lawyer literally everything. There's just no way that will work. And if this panel says that's what lawyers have to do, then this panel is setting up our lawyers to fail. And I don't think that that's what the ethics rules should be about. I think the ethics rules, I think we should be held to a high standard. I think prosecutors are in a critical position. I think absolutely that we should be disclosing information. Nobody disputes that. But we've come to a standard that I think if we take it, there's no intent requirement, there's no malice requirement, there's no materiality requirement. How can prosecutors do that? How literally can they do that? I don't think that they can.
Is it possible for us to find that there was not substantial evidence? Or let me phrase it another way. Is it possible for the board to decide that there is substantial evidence without getting to 309 or the 304 question?
Yes. If this panel on 3.09D, if this panel were to find that there was not substantial evidence of the statement, that Mr. Schultz heard the statement, I didn't see his face, I think this panel very well could rule that the other factors are inculpatory, and therefore they're not things that tend to negate the guilt under 3.09D, and there was no violation. Does that answer your Honor's question?
I think so.
Any other questions, anybody? Thank you very much. We appreciate it.
Thank you, Your Honor.
We will be in recess shortly.